All right, let's dive into a really fascinating legal puzzle. It all starts in a totally normal condo complex, but it ends up asking a surprisingly tricky question. This is the case of the mystery balcony. And it all really boils down to this one question. When you buy a condo, what part of it is actually yours? And more importantly, who owns that little blank space in between? So, our story kicks off at the Caribbean Gardens condominium in Phoenix, Arizona. Now, on the outside, it looks like pretty much any other community. But inside, a really strange fight was brewing over a piece of property that officially didn't even seem to exist. The whole conflict is about this outdoor space on the second floor, physically stuck right there between Unit 206 and Unit 207. It looks like a balcony, it feels like a balcony, but what is it really? Okay, so here are the key facts about this mystery space. It's a concrete slab with some railings, but here's the thing. The only way to get to it is through a door in Unit 207. So naturally, the residents were using it like their own private patio. But the real kicker? This space isn't on the official property map, the Plat, anywhere. It's basically a ghost balcony.
So this ghost balcony went totally unnoticed for years. That is, until one homeowner decided to pull out the blueprints, take a closer look, and start asking some really tough questions. And that complaint changed everything.
And that homeowner was a guy named John Klemmer. He lived downstairs in Unit 101. He saw the people in 207 using this space day in and day out and just thought, something here isn't right. So he went and filed a formal petition against his own homeowners association, the HOA. Klemmer's argument was actually pretty simple. He said that this mystery space wasn't a private patio at all. He argued it was a common area that belonged to all 40 owners in the building. And he believed the HOA was just letting one unit get away with taking it over. Now, to really get his point, you have to do the one thing every homeowner should do. You got to read the rulebook. Klemmer was convinced the answer was hiding in plain sight right there in the community's own governing documents. First up is something called the Plat. Just think of this as the master blueprint for the entire property. It's the official map that shows the legal boundaries of everything. If it's on the Plat, it officially exists. Simple as that. Next, let's look at the definition of an apartment. According to their rules, your unit is the space that's actually shown on the Plat. And that includes any patio or balcony that's specifically drawn and assigned to your unit on that map. And here, right here, is the crucial part. The rules define common elements as, well, basically everything else. It's all the other parts of the property that are not officially part of an apartment. So Klemmer's logic here was simple, but it was really powerful. He just looked at the Plat, saw that big blank space where the balcony should be, and concluded, hey, since this balcony isn't on the map as part of Unit 207, then according to our own rules, it has to be a common element. It belongs to everyone. But of course, the homeowners associations saw things very, very differently. They had their own interpretation of the rules and, frankly, the reality of how the building was actually designed. The entire case really just boiled down to these two terms. Klemmer was shouting, common area, for everybody. But the association fired back, no, it's a limited common element. And that's a special category with a whole different set of rules. The HOA's argument was really based on common sense. They said, look, the only door to this space is from Unit 207. It was obviously designed from day one to be used only by that unit. A board member even testified that the HOA had never maintained any of the balconies, always treating them as a private responsibility. So now you've got these two totally conflicting interpretations of the same exact rulebook. It all fell to an administrative law judge to sort through the mess and finally declare a winner. And the judge found the problem pretty fast. The community's documents, which were written way back in 1973, were just ambiguous. They were unclear. They didn't really account for a weird situation like this, which left enough gray area for both Klemmer and the HOA to have a decent argument. So if the community's own rulebook is basically a toss-up, where do you look for an answer? Well, the judge had to look outside the HOA's documents, to a higher authority. And this right here is the smoking gun. The judge turned to Arizona state law, and the state law had a crystal clear, decisive definition. It says that any balcony that's designed to serve a single unit,
even if it's technically outside the unit's official boundaries on the plat, is considered a limited common element that belongs exclusively to that unit. Boom, the state law just overrode the community's vague rulebook. And with that, the decision was simple. The judge ruled in favor of the association, and John Klemmer's petition was dismissed. The mystery balcony legally belonged to the residents of Unit 207. So, a weird little case about one balcony in Phoenix is over, but the outcome reveals some incredibly important lessons for anyone who lives in or is maybe even thinking of buying into a condo or a community with an HOA.
Here are the key takeaways for you. First, seriously read your community's governing documents. Know what they say. Second, and this is the huge lesson from this case, you have to know that your state's laws can sometimes completely override those documents. And third, really understand the difference between common elements, which are for everyone, and limited common elements, like a balcony or a parking spot, that are just for your exclusive use.
And that brings us to our final thought. This entire case blew up because of a blank space on a map. It kind of makes you wonder, do you really know where your property line ends and the common area begins? It might be worth checking the map.